Good morning, everyone. We are the fifth group to present, and today we're going to learn about intellectual property and such. My name is John David Cabajes, and I'll be the one to discuss the intellectual property. The copyright and intellectual copyright will be reported by Mr. Elijah de los Santos. Mr. Ivan Gonzalez will be reporting the industrial design and utility models. Ms. Sarah Nicole Padilla is the one assigned in patents and trademarks. The RA 8293 will be discussed by Ms. Shane Tano. And lastly, the IPO PHL will be discussed by Mr. Mark Lawrence Ventoso. So after ng ating discussion, malalaman natin kung ano nga ba ang ating tinutukoy na intellectual property, kung paano siya nag-work, at kung paano nakikinabang ang mga entrepreneurs, technopreneurs sa law na ito. Topic natin today na intellectual property ay galing sa dalawang salita, which is intellect and property, which means ito yung mga inventions and creations na hawak naman ng tao o hindi, na galing sa intelligence and creativity ng tao. So, ang example nito ay mga books na sinulat ng iba't ibang mga author and writers, mga recipes na naimbento ng mga chefs and cooks, mga brands, mga logo ng brands, and mga pangalan na ginagamit nila na ginagamit nga ng mga brands. So, paano nga ba nag-work ang intellectual property? So, yung intellectual property ay pinoprotektahan ng patents, copyrights, and trademarks na i-discuss din mamaya ng ibang reporter. So, nag-work yung intellectual property by giving financial benefit sa naka-imbento nito. So, binibigyan nito ng financial benefits o ng kita yung nung inventor nito ng kung sino mang gumagamit ng na-imbento nila. So, itong intellectual property ay hindi lamang nagbibigay ng financial benefits sa inventors sa kanilang inventions and creation. Ito ay nagbibigay din ng protection and recognition sa kanilang mga naimbento. For example, sa mga logo ng mga sikat na brand katulad na lamang ng Jollibee, yung B na nasa logo nila, ang pinaka-mascot nila ay protected by intellectual property and na-recognize sila na ibig sabihin, sila lamang ang pwedeng gumamit ng logos and mascots na yon. And kung sino mang gumamit nun without recognizing the inventor ay pwedeng makasuhan or mapabasahan sa ating intellectual property law. So, another example naman ay sa mga books na sinulat ng iba't ibang mga author. Yung mga books na ginawa nila ay protected din by intellectual property, and which means protected sila and recognized by intellectual property na sila lamang ang pwedeng gumamit nito, sila lamang ang nakaimbento, sila ang gumawa. So, kung sino mang gumamit ng book na to na without recognizing the author or gumamit nito ng illegal ay pwedeng makasuhan din based sa ating copyright law and sa ating intellectual property. So, yun lamang, and thank you.
Greetings to all of you. Name is Mr. Elijah de los Santos from BSAP 3A, and I'll be discussing to all of you our topic with regards to intellectual property rights as well as the copyright. But allow me to first read the content of our slide before we get started. So, speaking of intellectual property right, this refers to the rights given to the persons over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. So, since we are talking about creation of minds, this refers to all of the assets as well as the intangible resources that a particular organization or business use. So, for example, name, the private concept as well as the designs, and the promotion of right over intellectual property will help you to protect your ownership as well as to keep safe the time, the money, as well as the effort that you use for your business. So, intellectual property also have its subcategory or its types, and one of its types was the copyright, from which the copyright is a legal term used to describe the rights that creators have over their literary and artistic works, works covered by copyright range from books, music, paintings, sculpture, and films, to computer programs, databases, advertisements, maps, and technical drawings. So, copyright is a type of intellectual property or an exclusive legal right which is given to an originator to protect over his ownership. And yung matters na pwede nating i-protect gamit ang copyright are the software, the architectural designs, the graphic arts, video and sound recordings, books, and databases. We may now proceed to our next types.
My name is Ivan Clarence A. Gonzalez from BSCPE 3A. My report is all about industrial design. Any composition of lines or colors or any three-dimensional form, whether or not associated with lines or colors, provide that such composition or form gives a special appearance to and can serve as pattern for an industrial product or handicap. Industrial design is a process of design applied to physical products that are to be manufactured by production. It is a creative act of determining and defining a product's form and features, which takes place in advance of the manufactured or production of the product. The industrial design example is Coca-Cola Contour bottle, which is recognized by millions across the globe and is used on a daily basis by many people every day. The design is immediately recognizable, and this has been a case for over 100 years. And what is focus of industrial design? Industrial designer typically focus on physical appearance, functionality, and manufacturability of a product. The next is utility models. A utility model is a protection option, which is a design to protect innovation that are not sufficiently inventive to meet the inventive threshold required for standard patents application. What is utility model? Similar to patents, utility model protect a new technical invention through granting a limited exclusive right to prevent others from commercially exploiting the protected invention without consent of the right holders. For example, the ball pen is an existing invention, but you observe that when exposed to air, the quality of the ink decreases. So you have come up with the cover in the utility model.
Good day everyone, I am Sarah Nicole Padilla. So let us continue to discuss one of the types of intellectual property, patent. So a patent is an exclusive right granted for an invention. Generally speaking, a patent provides the patent owner with the right to decide how or whether the invention can be used by others. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. So, ang sinasabi dito ay ang patent ay para sa inventions ng mga inventors kung saan pwede natin iparehistro to become a patent owner. Kung saan magkakaroon ka ng legal na kapangyarihan sa kung saan mo gugustuhin gamitin o ipagamit ang iyong invention. So, patent is an exclusive right that allows the inventor to exclude others or mahadlangan ng iba na gumawa, gumamit, mag-import, or selling the product of invention during the life of the patent. So, patent is a territorial rights that has protection for a limited period. Usually, tumatagal siya ng 20 years for the date ng pagrehistro mo. Meron din pala tayo dito na example or 3 types of patent. Ito yung utility design and plant. Utility patents for tangible invention such as products, machines, devices, and composite materials, as well as new and useful processes. Dito sa utility patents protects the structural and functional features of the inventions. Pag sinabi kasi natin na tangible, it is an items that can be physically present, like the given example, products, machines, etc. Design patents, the ornamental designs on manufactural product. So it is the design patent that protects non-functional appearance. Ang kahibahan ng utility at design ay yung design kasi it is about how it looks, while the utility patents is about the way it is used and works to make it useful. Lastly, plant patents, new varieties of plant. Dito naman ay yung mga pag-angkin mo sa isang new varieties of plant dahil sa ikaw nga ang unang nakapag-discover or you created it. Next slide tayo. Dito naman tayo sa trademark. Trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks date back to ancient times when artisans used to put their signature or mark on their products. Pag sinabing trademark, ay may idea naman na tayo or familiar na sa atin itong words na to. Especially sa isang business, napaka-importante sa isang negosyo magkaroon ng trademark, lalo na sa malalaking company na ang goal ay mas makilala o sumikat international. Dahil nga, trademark is a unique symbol or word to represent the business. For example, I can identify which of these four trademark is McDonald's or Pepsi. And also, a trademark protect a business brand identity in the marketplace. Once na nakapag-rehistro ka na ng trademark mo, it gives the owner the exclusive right to prevent others from using the mark and also protect your right to sue or take legal action against other company that uses your trademark.
Good morning, I am Shane Tana and I am assigned to discuss RA 8293, or known as the Intellectual Property Code of the Philippines. A while ago, my group mates discussed about the types of intellectual property and the intellectual property itself. Now, I will discuss how are these intellectual properties can be protected. An act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for other purposes. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such periods as provided in this Act. The use of intellectual property bears a social function. This Republic Act 8293 is authored by the late Senator Raul S. Rocco and was signed into law in June 6, 1997 and took effect on January 1, 1998. What are the examples of violations of intellectual property? First, creating a logo or name meant to confuse buyers, thinking that they're buying the original brand. As an example, I am showing here a logo of original and fake logo of Adidas. Second one, recording video or music without authorization or copying copyrighted materials. And as an example, we all know or we are familiar with the copyright music used by the YouTubers. And now what if you made this kind of proven violation? What are the punishments for this? Republic Act Number 8293 or the Intellectual Property Code of the Philippines penalize patent infringement with imprisonment of 1 to 9 years plus a 50,000 to 1,500,000 fine depending on the number of offenses. Depending on the nature of the violations, penalties may include civil damages in the dollar amount of damage and lost profits, an injunction to stop the infringement, payment of the attorney's fees by the infringer, and felony charges with prison time.
So, what is IPOPIL? IPOPIL is the acronyms of Intellectual Property Office of the Philippines that was created by virtue of Republic Act Number 8293, or also known as the Intellectual Property Code of the Philippines. And IPOPIL is a government agency mandated to protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property creation, particularly when beneficial to the people for such period may be provided by law. So it is very significant and necessary for scientists, inventors, artists, writers, content creators, composers, and other people who put their talents, skills, and intelligence for their creation to have a government agency or office that will protect their intellectual property rights to their creation or inventions. An office that can prevent some people to take advantage to the work of others and use it without any consent or credits the rightful owners. IPOPIL vision is an intellectual property conscious Philippine in a domestified, development-oriented, and democratized intellectual property system in 2020, and its mission are a knowledge-driven government organization that works towards economic, technological, and social-cultural development by communicating, enabling, and ensuring the effective use of the intellectual property system in all levels of society for the creation, protection, utilization, enforcement of intellectual property. So, to put it simply, IPOPIL aims to have an IP-aware or intellectual property-aware community that promotes innovation which can lead to higher productivity, growth, and development of the country. And anyone who will prove and violate the intellectual property codes will be punished accordingly to the law. So, IPOPIL was mandated to perform the following major function. A is examine the application for grant of letters, patent for inventions, and register utility models and industrial design. B. Examine application for the registration of marks, geographic indication, integrated circuits. C. Register technology arrangement and settle disputes involving technology transfer covered by the provision of Republic Act Number 8293 on voluntary licensing, and develop or implement strategies to promote and facilitate technology transfer. B. Promote the use of patent information as a tool for technology development. E. Publish regularly in its own publication to the patents, marks, utility models, and industrial design issued and approved, and the technology transfer arrangement registered. F. Administratively adjudicate contested proceedings affecting the intellectual property rights, and G. Coordinate with other government agency and the private sector's efforts to formulate and implement plans and policies to strengthen the protection of intellectual property rights in the country. So that's the end of our report. Thank you for listening, and don't hesitate to ask any questions. Thank you.